Hey folks, it's Spitz with Pixels and Pills. It's my pleasure to have Mr. Darshan Kulkarni, expert in the realm where healthcare, regulatory and compliance, and technology converge. And our subject today is a captivating one. It's particularly timely, and it has everything to do with that small window ultimately the pharmaceutical companies have in terms of reaching out and engaging with physicians and even patients. Can you give us a little backgrounder on the current circumstance and how this might really impact the very nature of off-label and on-label communications?
Mike, thanks for having me, first of all. The thing we have to recognize is that the FDA has had a long history of making sure that the pharmaceutical industry only talks about what it's allowed to talk about, i.e., whatever the FDA has approved as the indication for use. The industry probably over the last decade or so, maybe a little bit longer, has been slowly chipping away at that process. Originally, it started off with the FDA saying no one can talk off-label. This is probably about early 2000s or late 1990s. And what you had was a situation where the pharmaceutical industry took the FDA to court and asked the courts to say you can't restrict free speech, especially if it's in the context of a scientific discussion. So what you had was a situation where no one could talk off-label. The courts took the FDA and said those limitations are unreasonable. It's an unreasonable restriction on free speech, and therefore certain people were allowed to talk off-label. Those certain people at that time were your medical affairs department, as long as it was in the context of a true scientific discussion, as long as you weren't engaged in advertising. And that original opening is now slowly being chipped away over the course of years, and starting with the breakthrough probably last year with IMS v. Sorrell, which was a Supreme Court decision as well. You're starting to see bits and pieces where the industry is getting together and eventually saying we aren't going to let the FDA limit free speech. So what you have was the latest salvo, the Alfred v. Coronia case, which effectively allows that in the Second Circuit, the industry is allowed to talk off-label. But that's
well, hold on one second. That's kind of a bold statement.
Exactly. That's a very bold statement. It's not the complete story.
As you mentioned before, in terms of medical consultancy, there were rulings which allowed, obviously, skilled, authoritative healthcare professionals to have some of these off-label discussions outside the context of what would overtly be considered a marketing environment.
Absolutely.
That's correct. So the Coronia case now takes it to the next level in the sense that you've got a sales rep, ostensibly in advisement from some of these same medical professionals, discussing off-label topics that are nonetheless truthful, non-misleading, and scientifically accurate with a physician within the context of what could be considered a marketing pharmaceutical sales pitch. And the defense seems to be that the sales rep, as a citizen of the United States, has the First Amendment right for free speech, and therefore should be allowed to discuss topics which are, again, truthful, non-misleading, and scientifically accurate within that context, and not feel repercussions for doing so. Is that an accurate assessment of where we are today with regard to the ruling?
Well, it's again what I said. Let's first of all qualify what we're talking about. We aren't giving legal advice here. Anyone who listens to this hangout should not interpret what I just said as legal advice. We can discuss it longer, but that's not the goal at this second. we also have to recognize the limitations of the ruling that came out. The ruling is very specific. It's only to the Second Circuit. Other circuit. So we should explain what a circuit is, because everyone understands what the courts are. But a circuit is in the federal system of the courts. There are multiple circuits, and each circuit is a group of different states clubbed together. For example, I live in Philadelphia, and I live in the Third Circuit, which includes a couple of different states, including New Jersey, Pennsylvania, I believe the Virgin Islands. The Second Circuit is the one we're talking about, which is where you are, which is New York, and I believe Connecticut and Vermont. And the courts there came up with the ruling. So we have to recognize that what we have is something that only the Second Circuit has said. No one knows if that Second Circuit's ruling will be upheld across the board, whether other circuit courts will adhere to that ruling. It's not binding on any other courts. So,
but I think might be a newsflash though to a lot of our listeners and viewers is that the Second Court, as you described, not the Supreme Court, did actually rule in favor of this sales rep. The repercussions being ostensibly that sales reps within the context of even a marketing conversation with physicians technically are able to and protected by their right to free speech discuss off-label uses for the drugs that they're marketing.
I'm trying to decide. Your statements are factually correct. The implications are what's being debated right now.
Great, and let's take that into our next segment then, where we discuss the implications of what actually this could mean.
Okay,